Bill, State of Michigan versus Dwayne Hatch, Washtenaw County Sheriff's in 2151032. Good morning.
Good morning, Your Honor. Patricia Reiser on behalf of the people.
Good morning, Your Honor. Andrew Meyer from the Washington County Public Defender's Office on behalf of Mr. Hatch.
Thank you. All right. The allegations matter is on July 29, 2021. Ypsilanti Township, Washtenaw County, State of Michigan at 2851 Binen Drive. The allegations of the defendant did murder Antonio Bishop. This is a felony carrying a maximum term of up to life in prison. Do you understand that, sir?
Yes.
Count two, you did make an assault or assault and battery upon Lila Sykes with the intent to do great bodily harm, less than the crime of murder, or by strangulation or suffocation. A felony carrying a maximum penalty of a term of up to 10 years in prison or $5,000 fine, or both if convicted. Do you understand that?
Yes, sir.
And count three, you did carry a dangerous weapon identified as a pistol concealed on or about your person. A felony carrying a maximum penalty if convicted of a term of up to 5 years in prison, a $2,500 fine, or both. Do you understand that?
Yes, sir.
Court does need you to advise of your rights. You do have the right to remain silent. And you say in the record can and would be used against you at trial. Do you understand that?
Yes, sir.
You also have the right to be represented by an attorney at all stages of these proceedings, including before, during, after trial, and at any time you're being questioned by a police officer. If you are unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes, sir.
Court will have you stand mute to all charges, enter not guilty pleas as to each count, and take a petition for the public defender to represent you in this matter. Court's been provided information by the public defender that you currently reside in Washtenaw. Is that correct?
Yes.
Okay. All right. And you're been working at is it Miser? Is that right?
Yes, sir.
Okay. You've been there for about a month now?
Yes, sir.
All right. Based upon information provided, the court will endorse a petition to appoint a public defender to represent you in this matter. As these are felony charges, you have a series of court dates that will take place here. The first hearing is what's referred to as a probable cause conference that will be scheduled on August the 12th. Should the matter not be resolved that day, hearing will proceed to a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that there's probable cause crime was committed, probable cause you did commit the crime. Should the judge presiding over that hearing determine probable cause does exist, the matter would be bound over, in other words, transferred to circuit court for trial. Do you understand that?
Yes, sir.
That hearing will take place on August the 17th, also at 9 a.m. All right, people want to address bond in this matter?
Yes, Your Honor. The people are requesting denial of bond pursuant to MCR 6.106B sub 1 sub little a sub little I because the defendant is charged with murder. Obviously, he's also charged with 2 other very serious felonies. In this case, the great bodily harm charge was domestic. It was strangulation, choking of the defendant's ex-girlfriend, Lila Sykes, who is the mother of the defendant's child. There's significant evidence showing the defendant's guilt. He had been in a relationship with the great bodily harm victim, Sykes. They had a child in common. The defendant went to her apartment to pick up their child. He wanted to come into the apartment. She would not let him in. They were loud and he assaulted her, including strangulation and choking. Neighbors heard this. One of them called 911. Antonio Bishop, who is the murder victim, was in the apartment. He heard it. He came outside to see what was going on and confronted the defendant. The defendant pulled a pistol from his pocket, and he did admit that he had a gun in his pocket when he was interviewed by the police. He actually indicated that he had bought that gun to commit suicide. He pulled the pistol from his pocket. He shot Bishop several times, mostly in the face, head area. The autopsy is happening right now. I've just been advised recently by the officer in charge, indicating that the victim was hit with 13 rounds, primarily in his face. Additionally, the preliminary ballistic evidence is consistent with several bullets being fired into Bishop's head while he was on the ground and the defendant standing over him. So given all of these circumstances and pursuant to the court rule, we are asking for denial of any bond here.
Thank you. Mr. Meyer?
Good morning again, Your Honor. Andrew Meyer on behalf of Dwayne Hatch. Obviously, Mr. Hatch and I did have some time this morning to discuss the charges as alleged in the charging documents. We reviewed that. We do appreciate that Your Honor reviewed it again with Mr. Hatch. We obviously understand the serious nature of the allegations here, given that this is alleged to be a homicide and a serious assault. However, I would note that Rule 6.106 does, it is a may, not a shall rule. Michigan is not a state that automatically denies bond in cases where there is an allegation of homicide. Mr. Hatch did indicate to me that prior to this incident, he was homeless. He was staying in his car. He did provide me with an address, and that's his mother's address, and that's who he was going to be moving in with shortly before this alleged incident occurred. He has 4 children, ranging in ages from 6 months old to 7 years old. As the court has already seen, he is employed. He's been working for the last month. He's completed the 12th grade. Perhaps though, and this may be what is probably the most important factor in this case, is Mr. Hatch's mental health diagnoses, which he indicated to me this morning include schizophrenia, bipolar disorder, and ADHD. And he had previously been diagnosed by community mental health and prescribed numerous medications, which he indicated to me he hasn't been taking for some time. He also indicated that he has previously been psychiatrically hospitalized. We understand, again, the serious nature here. We don't think an outright denial is necessary here, but perhaps a cash bond is what ought to be put in place here.
Thank you. People have any response?
Your Honor, I would agree that the court rule says may. However, the evidence that I outlined it just indicates that the great weight of the evidence is against the defendant here. And despite the mental health issues, which I would point out make him more dangerous to the public if he's not taking his medication, I am asking the court to deny bond.
Thank you. All right. So as our argument indicated, the court does need to make a finding in this matter prior to making a determination in bond. Finding has to include that there be a likelihood of conviction and or a presumption of guilt has to be raised and met pursuant to the police information provided in the swear to and on the face of the complaint. In addition to that, additional information provided by the people at arraignment, the court is satisfied those conditions are met and the court rule can be applied in this matter. Therefore, bond is denied. All right, so your next court date will be August the 12th at 9 a.m. You will be remanded to custody of Washtenaw County Sheriff until such time as that hearing can take place. All right, thank you, everyone.
Thank you,
Your Honor.
Mr. Hatch, good luck to you, and please don't talk to anyone about this case until you see your attorney.
Understood.
Okay, Mr. Hatch, can you let them know you're done?
I'm sorry, what's that?
You can let the corrections officers know you're done.
Okay.
Call up front, just make sure, I don't know if that broadcast out there or not, but you can let him know that we are done. Hopefully it got out there.
Is there a next one you would like in a certain order, or you guys, just doesn't matter?
Whatever works best for your guys' flow down there, I think it's fine with us.
Okay, I'll get the next one up.
Thank you. Good morning.
Good morning.
Your name, please?
Dominique Gardette.
I'm sorry, one more time?
Dominique Gardette.
Gardette, thank you, Mr. Gardette. Just give me just 1 second, okay? Appeal State of Michigan versus Dominic Gardette, case numbers 20 FB 192821 FB 1474.
Chad Rajley on behalf of the people. Good morning.
Good morning.
Morning, Judge. Torshio Feaster, Assistant Public Defender on behalf of Mr. Gardette.
Thank you. All right. Were you able to review the complaints with Mr. Gardette?
We were, Judge. He will waive reading and stand mute, Judge.
Thank you. Mr. Gardette, the court needs you to advise you certain rights. These are felony charges. You do have the right to remain silent. Anything you say on the record can and would be used against you at trial. Do you understand that?
Yes.
You also have the right to be represented by an attorney at all stages of these proceedings. This does include before, during, after trial, and any time you're being questioned by a police officer. If you're unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes.
Court, I will stand mute to all charges, enter not guilty pleas, and take a petition for the public defender to represent you in these matters. The information provided by the public defender this morning indicates that you reside on Nash. Is that correct?
Yes, sir.
Best telephone number to reach you is as 1179 in the last 4 digits.
Yes, sir.
Okay. And you're currently unemployed and have no source of income.
Yes, sir.
Court will endorse the petition to appoint the public defender to represent you in each of these matters. All right, the people addressing bond in these matters, the court has reviewed the bond recommendation forms. Is there anything in addition to the forms?
Nothing additional, Your Honor. I would just note that since this is a 2020 charge, this seems to just be an outdated version of our bond form. I just amend the cash request to a surety amount instead to align with my office's current policies. I would note for the court that over the past decade or so, Mr. Gardette has assaultive history outside of the DV charges.
Okay, thank you. Mr. Feaster, do you address bond?
Yes, Judge. Thank you. Just briefly, I did meet with Mr. Gardette this morning. We did discuss these matters. Obviously, he knows he has some things to deal with on these files. Both of these charges appear to be fresh charges. He does not have any failure to appear on these matters. He's indicated that he will come to court on these matters should he be given a bond in this case. He does have one minor child that he is providing for. He is not on probation or parole of any type, and he has nothing else holding him aside from these cases. He does acknowledge he does have prior cases with the alleged victim in this matter. He would have no problem with a no contact or no go-to in either of these files with the officer or with the alleged victim on the home invasion domestic violence case. He'd asked Your Honor to consider a personal bond in this matter. If the court is uncomfortable with that, Your Honor, he would also like me to urge you to consider a low bond. I understand that the prosecutor is asking for 50,000 cash or surety. He would not have any possibility of being able to afford that. He'd like it to be somewhere in a range that he could possibly afford it. If the court is comfortable with that, he'd urge me to ask Your Honor to consider a tether. He would have no problem being on a tether and staying away from any hot zones that this court feels is necessary. And so those are the things we would request for this morning, Judge.
And Mr. Feaster, are there any other warrants outstanding aside from the two new felonies here?
Just these, Judge.
Okay. All right. And how did Mr. Gardet end up getting arrested?
Your Honor, this was a traffic violation. Mr. Gardet was a passenger in the back seat of a vehicle,
That's
and
fine.
and they stopped him and ran his name and saw he had these two warrants, Judge.
Thank you. Okay. Do people have any response to defense counsel's bond argument?
No response, Your Honor. I'll just add that I don't have any recent confirmation that the victim, Miss Bailey, is still at that Dorset Avenue address. But if the court could just enter it as a no-go to as a precaution, and we'll try to follow up with her and see if there's been an update since last year.
Okay. Mr. Gardet, do you know if Miss Bailey is still at the Dorset address?
I believe so, to my knowledge. I haven't spoken with her in a few weeks.
Okay. All right. As the case number 20FB1928, court will set bond conditions to ensure public safety. These conditions are the defendant is not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card, sir?
No.
Okay. Defendant is not to leave the state of Michigan without permission of the court. Defendant is not to possess or purchase firearm, ammunition, or other dangerous weapon. Are there any firearms in at the Nash household?
No, sir.
Okay. Not to commit any assaultive, terrorizing, frightening, intimidating, threatening, harassing, molesting, or stalking behavior towards any individual. Not to have contact with Irene Bailey. This means absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, two-way video contact, or any contact of any sort whatsoever. Do you understand that?
Yes, sir.
Not to go to the defendant's place of residence or employment. Once the Nash and Dorset are in the same neighborhood, right?
Yes.
Give me just one moment. I want to look up one more data point. Give me just a second to get that program started. Do you have JS started? You look at this last case. Appearance record wasn't bond. All right, well, again, that information, let me get the next court dates out there on the record here. We have probable cause conference will be set for August the 12th at 9 a.m. Should these matters not be resolved at that hearing, the matter will proceed to a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that there is probable cause the crime was committed, probable cause defendant committed the crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred to a circuit court for trial. Do you understand that?
Yes, sir.
Okay. Yeah. Right. So at arraignment, what happened? Was there a bond and did he appear for his next witness? Right, no, that's fine. That's fine. And did he fail to appear for any court meetings? Okay. Mr. Gardner, we're just checking your last court case does appear you did appear for all of your court dates. So, flight risk is not an issue here. The primary driving concern for the court is public safety. Court needs to determine between a combination of conditions and possibility of imposition of monetary bond or surety bond to determine what was necessary to ensure public safety. You've been residing in this area the entire time since your last charges and these charges came up?
Yes, sir. 1115 Nash.
Okay, and you've had no police contact other than when you got arrested the other day since sometime last year or the year before?
True.
Okay. All right. And you understand this condition is an absolute bar on contact.
Yes.
And you understand that it's put in place to assure public safety and to assure the safety of the alleged victim in this matter. That means she should be left alone entirely. You understand that?
Yes, Your Honor, I understand.
Okay. And although the case numbers appear to be out of order, and this is right. Is that right, Mr. Haragley? The resisting obstructing occurred prior to the alleged domestic violence. Is that right?
That's what I have, Your Honor.
Okay. Okay.
Domestic violence would have been December 10th of last year.
Okay. So we're not talking 8 months in the rear view. Okay. Mr. Feaster, anything else on bond?
No, Judge, thank you.
Okay. So, all right. So the conditions here be placed in the law enforcement information network, meaning should you come into contact with the police, the police would have access to that information. Should they witness or suspect a bond violation occurred, you would be arrested for that bond violation. You understand that, Mr. Gardette?
Yes.
Okay. The two obvious points of problem that defendants have in these matters are intoxication or contact with the protected individual, or a combination of those two, frankly. And that's not to mean that all the others don't matter as just as much, but those are the ones where people get tripped up the most. So make sure you keep an eye on those things. The proximity of your two homes means you need to be vigilant. If you see her in the neighborhood, you need to go the other way. Okay?
Understood.
Okay. All right. I'm sure at future court hearings, once the people can establish what her address is, they may ask for that tether. Right now, the court has a little difficulty doing it without the confidence of the address as to where to tether from. But if that is requested in the future, the problem that you may encounter there is you may need to move out of the area because the tether zone is going to be X number of, whatever it's going to be, feet, yards, miles, whatever it may be. But that's not for today's hearing. I can't order a tether without a specific address to keep you from. All right. Anything else on bond from either the people or the defendant?
No, Your Honor.
Nothing from me, Judge.
All righty. All right. Court will set $25,000 personal recognizance bonds in each case. All right, Mr. Gardette, that means you are free to go today. But if there's any violation of any bond condition or fail to appear for a court date, the bond is automatically $50,000 right off the bat, and then the judge may decide to make it higher from there. You understand that?
Understood, Your Honor.
Okay. All right. You're all set. Stay safe. Okay.
Thank you.
Thank you, Judge.
Thank you.
Morning, Your Honor.
Good morning. Your name, please?
Dwayne Miller.
Thank you, Mr. Miller. I'll be with you in just one moment, okay?
Okay.
Start at number 2. Actually, I do it real quick. Okay, Mr. Miller.
Yes.
Field State of Michigan versus Dwayne Miller, Ann Arbor City Police Department, incident 2125047. Good morning.
Good morning.
Shadow Rajla on behalf of the people, Your Honor.
Good morning, Your Honor. Andrew Meyer on behalf from the Washington County Public Defenders on behalf of Dwayne Miller.
Have you reviewed the complaint with Mr. Miller?
We have, Your Honor, and we waive any reading.
Thank you. Mr. Miller, you understand the misdemeanor charge here, 2 charges you're facing here?
Yes.
Okay, you've read and signed the advice of rights form?
I don't know that he's executed that yet, Your Honor. That would probably be forthcoming if he has not.
Well, it was sent up to us. Mr. Miller, did you read an advice of rights form on a computer and sign an electronic form?
No.
No? Do you have an advice of rights form? Give me just a moment. I'm getting in the form so I can read it to you on the record.
Okay.
You've been brought to court on a misdemeanor charge and have the following basic rights. You may plead guilty or not guilty or stand mute. For today's purposes, the court will have you stand mute to the charge and enter a not guilty plea on your behalf. At a later date in these proceedings, you may plead no contest with permission of the court. You do have the right to trial by jury and the right to an assistance of an attorney. If you're unable to afford an attorney, one will be appointed to represent you at public expense. Should this matter go to trial, you would have the following rights at your trial. You may call witnesses to speak for you at trial. You may get an order compelling witnesses to appear on your behalf. You have the right to see, hear, and question all witnesses against you at trial. You have the right to be a witness for yourself or to remain silent. Should you choose not to testify, the prosecutor may not comment on your refusal to testify, and you are presumed innocent until proven guilty beyond a reasonable doubt. Do you understand that?
Yes, I do.
Okay. Should at any time in these proceedings you choose to plead guilty or no contest and that plea is accepted, you will not have a trial and will waive your rights that you would have at that trial. You do have the right to be released on bond. If you are now on probation or parole and enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. Fines, costs, and other financial obligations must be paid at the time of assessment, except when allowed otherwise for good cause shown. An appeal to circuit court may be taken within 21 days of sentencing or is permitted by court rule. Do you have any questions with regard to these rights?
No.
Mr. Meyer, you satisfied your client's been advised of his rights?
I am, Your Honor, and I apologize. He does stand mute with respect to the charges. I think the court had already indicated that.
Exactly. Yep. All right. Mr. Meyer or Miller, excuse me. You live on South Edsel in Detroit, is that right?
Yes.
Okay. The best telephone number to reach you is ends in 2075.
Yes.
All right. And you've been working Instacart for the last year or so?
Yes.
All right. Okay. And the public defender collected an email address from you that ends in olco@gmail.com. Is that the correct email address?
Yes.
All right. Reason the court collects telephone and email addresses is the court may contact you in the future via email or text. Is it okay we do that for with those two locations?
Yes.
All right, excellent. Based upon the information provided, the court will appoint the public defender to represent you in this matter. Mr. Meyer, do you want to address bond?
Certainly, Your Honor. Again, Andrew Meyer on behalf of Mr. Miller. That address in Detroit is Mr. Miller resides there on his own. I believe it's a rental. As was indicated, he is working for Instacart. I think he takes about $700 a week home doing that. And he also indicated to me that he completed some college at Washington Community College for video game design, and he has sort of a passive income stream for that as well. He doesn't have any children of his own. As I indicated, he has some college. Mr. Miller indicated to me that in around 2018, he was involved in a rather serious motor vehicle accident to which he suffered a traumatic brain injury and was in treatment for some time for that. He's also a yoga instructor. With respect to the charges, I don't necessarily want to get into the specifics of the allegations, but I would indicate to the court that this appears to have been Mr. Miller, who was accompanied by some of his friends from Detroit, were visiting Ann Arbor. They went to a restaurant establishment. There was an argument that broke out between one of the security personnel at that establishment and Mr. Miller's friend, and he attempted to break it up, at which point the Ann Arbor police were called and Mr. Miller was arrested as part of that. These are only misdemeanor charges. Mr. Miller has a fairly limited criminal history. I believe he's not a flight risk either, nor is he a threat to the community. And I believe a personal recognizance bond is appropriate. I think that's also what the state is asking for in this matter.
Thank you. I apologize. Did people want to address bond?
I am requesting a personal recognizance bond, Your Honor. One thing I did neglect to mention in the bond form is that I do unfortunately believe this whole incident was kind of fueled by alcohol use. There was a preliminary breath test at the Ann Arbor Police Department when Mr. Miller was being booked and processed there, and he was a 0.15, and that's grams of alcohol per 210 liters of breath. And I'm referencing Ann Arbor Police Report 21-25047 for that information. So a condition of no use of alcohol and perhaps alcohol testing might be appropriate.
Thank you. All right. Okay, Mr. Miller, your next court date will be a pretrial hearing. I didn't think dates for pretrial. No,
Okay.
August. Thursday, August 12th at 9 a.m. That'll be held at the 15th District Court, but it will take place via Zoom. So what should happen next is you will receive a notice in the mail from the court. Included in that notice will be the Zoom information. Are you familiar with Zoom?
Yes.
Okay, so there'll be a Zoom ID number there. You plug that in. What'll likely happen is you'll end up in a waiting room. Just imagine if you've been to court before, the courtroom's full, the waiting room's gonna be full too. So just if you're in the waiting room for a period of time, just be patient. They'll bring cases in a few at a time or one at a time, whatever the case may be. But so you may be in the waiting room for a few minutes. Is my point. So just be patient with that process. Okay.
Okay.
All right. All right. Condition of bond, the defendant is not to leave the state of Michigan without permission of the court. not to violate any criminal laws, and is not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card?
No,
Okay. The condition, particularly the condition of no use or possession of alcohol, illegal drugs, or marijuana, will be placed in law enforcement information network. And should you come into contact with the police, they would have access to that information. Should they witness or suspect a bond violation based upon observations, you could be arrested for that bond violation. You understand that?
yes,
All right. Do people have any further comment on bond?
No, Your Honor, thank you.
Mr. Meyer, anything else on bond?
No, Your Honor, thank you.
Defendant's released on a personal recognizance bond subject to conditions placed here on the record. Again, pretrial will be August the 12th at 9 a.m. You'll get a preliminary notice of that today with the date and time. And like I said, Mr. Miller, you want to watch your mail for the notice with the Zoom information. If you don't receive that in what you feel is a timely manner, you can always call the court, the 15th District Court, and the clerk can give you that information over the telephone. And of course, the public defender will be in touch with you before your next court date as well. Okay.
okay,
All right, you're all set, sir. Stay safe. Okay.
all right, thank you, you too,
Good luck to you, Mr. Miller.
thank you. Good luck.
Eight 12 is that patrol? Morning, sir. Your name, please. Can you hear me, sir?
Carol
Good
Taylor.
morning. Taylor?
Carol Taylor.
Thank you.
Yes.
We lost video down there in the jail.
They're back. It's the connection's really bad with that part of the prison or the jail, Your Honor.
There we go. All right. Mr. Taylor, can you hear me okay?
Yes.
Okay. Phillips Lane Township versus Daryl Taylor, Washington County Sheriff's Incident 2151315. Mr. Meyer, I assume you didn't have an opportunity to review this complaint?
I did not. I did not see it loaded when I checked just when I met Mr. Taylor. I'm sorry, Your Honor.
It's a township case. They don't load.
Oh,
So
well, that's
it's on
why.
paper. Yeah. All right. So anyway, Mr. Taylor, the allegation of this matter is that on July 30, 2021 in Ypsilanti Township, Washington County, state of Michigan, at 2895 Bynum Drive, you did make an assault or assault and battery upon Angelique Foster, a person with whom you reside or formerly resided with, and or a person with whom you have or had a dating relationship. This is a misdemeanor carrying a maximum penalty if convicted of up to 93 days in jail, a $500 fine plus court costs, or both. Do you understand that?
Yes.
Were you able to read and sign the advice of rights form this morning?
Yes.
Do you have any question with regard to your rights?
No.
The court will have you stand mute to the charge, enter a not guilty plea on your behalf, and take a petition for the public defender to represent you in this matter. Based upon the information collected by the public defender, the court will appoint the public defender to represent you in this matter. I just want to verify a couple of data points. Your telephone number is 0159, is that correct?
Yes,
And your email address ends in 1226 at Gmail?
yes,
All right. Those two points of information the court may be using to contact you in the future, either by text or email. Is that okay?
yes.
Okay. All right. Township attorney is not here to address bond. We do have a bond recommendation form. Mr. Myers, excuse me, were you addressing bond for this matter?
Good morning again, Your Honor. Andrew Meyer on behalf of Daryl Taylor. I did meet with him this morning. I was aware of the charges. I obviously didn't have the charging documents. Mr. Taylor resides at that address that the court had there. However, that was with the alleged victim in this matter, as well as her child. The relationship between the alleged victim and Mr. Taylor is one of girlfriend and boyfriend. We discussed whether or not Mr. Taylor had another residence to reside at during the pendency of this matter, and he believes he can reside with his sister if the court were to order a no-go-to order. Certainly, if the alleged victim were to leave the residence, then perhaps that could be readdressed at a later time. As is indicated in the paperwork that the court just reviewed, Mr. Taylor is employed. He works at Benzo Shipping and Receiving, and he has worked there for the last 8 months, and he earns a pretty good salary. He has completed some college. He enjoys generally good physical and mental health. He only suffers from some gout in his feet. I don't believe he's a flight risk or a threat to the community, given that this is just a misdemeanor charge. I think this was, in essence, at least what's alleged, a verbal argument that may have educated to or escalated to a pushing and shoving type situation. So it's not as if any grievous bodily harm or anything like that is alleged here. With that being said, I believe Mr. Taylor would be an appropriate candidate for a personal recognizance bond with the standard domestic violence conditions in place with no contact.
Thank you.
And he understands that.
Thank you. All right. Mr. Taylor, the court is going to set certain bond conditions to assure public safety in this matter. Those conditions are that you're not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card?
No,
Okay. You're not to leave the state of Michigan without permission of the court. You are not to possess or purchase a firearm, ammunition, or other dangerous weapon. Do you own any firearms?
no,
You are not to commit any assaultive, terrorizing, frightening, intimidating, threatening, harassing, molesting, or stalking behavior towards any individual. You're not to have contact with the alleged victim in this matter, identified as Angelique Foster. By no contact, court means absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, or any contact of any sort whatsoever. Do you understand that?
yes, sir.
You're not to go to the address of 2895 Bynum Drive in Ypsilanti, Michigan. However, you may return there to collect personal belongings under what's called a civil standby. What that means is when you get out of jail, you need to contact the sheriff's department, tell them you have a civil standby order. They'll know exactly what that's about and walk you through their process to get you over there with escort to collect any personal belongings. Okay.
Okay,
All right. Mr. Meyer indicated that you may be staying with a family member. The information you're going to receive this morning will include a telephone number for the court. You need to contact the court within 24 hours to provide an address as to where you'll be.
okay,
That number will pick up day or night and just leave a message there. Okay.
no problem.
All right. Of course, you're not to violate any criminal laws. You need to appear for all your court hearings and other places as directed by the court. Do you have any questions with regard to any of these conditions?
No, sir.
Okay. Mr. Meyer, any comment on conditions?
No, Your Honor. Thank you.
All right, Mr. Taylor, these conditions will be placed in what is called the Law Enforcement Information Network, meaning should you come into contact with the police, they will have access to that information. Should they witness or suspect a bond violation have occurred, they would arrest you for that bond violation. Obviously, an arrest on a bond violation decreases your chances of not being in jail while the matter continues along, okay?
Yes, sir.
All righty. Let me just check one other thing. I saw a note on one of these things I need to double check. Are you on probation or parole right now?
No, sir.
Okay.
We discussed that. The court may be seeing what I saw this morning. I believe that may just be for fines or child support, at least
Okay.
according to Mr. Taylor. So If there's
Okay.
another hold, I guess I'll find out about that.
Okay. All right. And, all right, what types of charges did you have in Florida and Louisiana?
Driving without a license.
Okay, no, nothing assaultive down there?
No, sir. No,
Okay.
sir, not at all.
Okay, all right. Let's see here. So then your next court date is the next piece of information we need to work out. Okay, we'll set this for a pretrial here on August the 9th. What context? Do you have copies of that one? Okay. All right. Okay, we'll set this for pretrial on August the 9th. That'll be the 14B District Court at 9 a.m., but it will take place via Zoom. Are you familiar with Zoom, sir? Mr. Taylor, are you familiar with Zoom?
No, sir.
Okay, so Zoom, it's exactly what we're communicating on right now. It's an app or a website you can go to. And the public defender, when they talk to you next, will walk you a little bit through the process. But as long as you have a smart device, whether it's a tablet, phone, computer that has video communication capability on it, you jump on there. You're going to punch in what's called a Zoom ID number. The court's going to mail you that to you. So that's why it's important we get to the address as to where you're going to be, so we can send you that information. If that doesn't catch up to you, you can always call the court. The clerks can give you the Zoom ID information over the telephone. But the process is, once you go to either the Zoom website or the Zoom link, Zoom app, you punch in that number, it's going to take you into what's called a waiting room. So you should see when you get there, you'll be in Judge Washington's waiting room. And as if you are in normal court, there'll be a number of people in that waiting room with you. You can't see them because you're there virtually. So it may take some time for your case to get called. Just ask you to be patient while you're there and stay by your phone. So when your case does get called, you're there and ready to go. Okay.
Okay.
All right. Okay. August 9th at 9 a.m. will be the pretrial hearing. Defendants released on a personal recognizance bond subject to conditions placed on the record. Should you fail to appear for the court or violate a bond condition, a warrant would issue for your arrest. Do you understand that?
Yes, sir.
Okay. I'm told that there may be other warrants for you. So if that is the case, you would be held until you be seen on those. Oh, I'm sorry. There's somebody else that has a similar name to you. So disregard that.
Yeah, I actually thought Mr. Taylor was someone else too. Yeah, you don't want to be confused with that guy.
And I was like, huh? I don't even know what that said.
Okay. All right.
Yeah.
Well, I'm glad we were able to clear that up. All right. So anyway, August 9th, 9 a.m. for pretrial. Public defender will be in touch with you before your next court date to talk to you more about your case. Okay.
Okay.
All right. You're all set, sir. Stay safe. Okay.
Good luck, Mr. Taylor.
So how, am I getting out today or
Assuming there's nothing else holding you, yes.
or I gotta wait?
And like we just said, there's another individual who has like one letter difference in their first name that is not going to get out, and you're not that person.
So
So
I am getting out there.
okay. Good luck to you, sir.
Okay, so I am getting out today?
Barring any other warrants that we're not aware of. On this case, you're free to go. So,
Oh, okay.
Yeah.
Okay. So I can call my job.
all right. All right. You're all set. Stay safe, sir. Okay.
Thank you.
Is there anybody you need to see from up in the ITR?
Yeah, we have 4 more folks.
One more? All right.
That looks like it's everyone I have back here, so I let them know whoever you guys want have else to see.
Okay, all right, sounds good. Thanks for your help this morning.
All right, thank you.
Morning, sir. You hear me?
Yes,
Excellent. Your name, please?
Norman Johnson.
Thank you, Mr. Johnson. Bill, State of Michigan versus Norman Johnson, Washington County Sheriff Incident 2151224. Good morning.
Morning, Your Honor. Jed Rajley on behalf of the people.
Morning, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Mr. Johnson. Your Honor, the charges came through after I met with Mr. Johnson. The initial paperwork indicated it might have been an armed robbery. It came through as a home invasion third and a larceny. Would you mind please reading that?
Absolutely. The allegations in this matter are that on July 30, 2021 in Ypsilanti Township, Washington County, State of Michigan, at 8813 Lagoon Drive, the defendant allegedly did break and enter or enter without permission a dwelling at 8813 Lagoon Drive, and while entering, present, or exiting the dwelling did violate a bond or bail condition or any condition of pretrial release ordered to protect LaShawna Hall. That is a felony carrying a maximum penalty if convicted of a term of up to 5 years in prison, a $2,000 fine, or both. You understand that, Mr. Johnson? Count 2, the allegation is that you did commit the offense of larceny by stealing a cell phone belonging to LaShawna Hall. The value of property stolen was $200 or more, but less than $1,000. A misdemeanor carrying a maximum penalty if convicted of up to 1 year in jail, a $2,000 fine plus court costs, or both. You understand that, Mr. Johnson?
Yes, yes.
Okay. As there's a felony count here, the court does need to advise you certain rights. You have the right to remain silent. You say on the record can and wouldn't be used against you at trial. Do you understand that?
Yes.
You also have the right to be represented by an attorney at all stages of these proceedings. That does include before, during, after trial, and any time you're being questioned by a police officer. If you are unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes.
Court will have you stand mute to the charge, enter a not guilty plea on your behalf, and review the petition appointed by the public defender. Public defender collected information for you and placed it on the request for court-appointed attorney form, indicating the best telephone number to reach you ends in 1421. Is that correct?
Yes.
And you reside at Thetford Lane in Willis. Is that right?
Yes.
Okay. All right. And you're okay. And your email address ends in 88 at Gmail. Is that right?
Yes.
Okay. All right. Reason we collect phone and email addresses is the court may contact you in the future with information about your case, either by email or text. Is it okay to do that?
That's fine.
Okay. All right. Court will endorse the petition appointing the public defender to represent you in this matter. Do the people have anything on bond?
Yes, Your Honor. As indicated on the bond form, I'd be seeking a $50,000 surety bond here as an alternative if the court is inclined to release Mr. Johnson. think a GPS tether would be necessary under these circumstances, namely because Mr. Johnson was already prohibited as a bond condition from visiting the Lagoon Drive address. That's pretty apparent from the charging there.
I apologize. My computer just said it's going to die here. It's like I need to get a cord and plug in. Hold on
Sure.
just a second. Okay. Mr. Johnson, I apologize for that interruption. We just need to keep the equipment going here. So we're all set now. People may continue.
Thank you, Your Honor. I was just wrapping up with saying that I do believe a GPS tether is necessary and appropriate here. Mr. Johnson was already prohibited from going to the Lagoon Drive address and contacting Ms. Hall as part of his bond conditions in an already charged domestic violence case. And of course, here we have this situation where he's again found at her address. According to the police report, she did call emergency services successfully, after which Mr. Johnson took away Ms. Hall's phone to ensure that she wasn't able to call again, according to her. There are multiple prior assaultive charges, many of them involving Ms. Hall over the past few years. I do believe there's a high risk of lethality given the repeated assaults, and the GPS would at a minimum ensure that there's no physical contact between the parties pending a resolution in the case.
Thank you. Mr. Feaster, do you have a response?
Yes, thank you, Judge. Your Honor, I did have a chance to meet with Mr. Johnson this morning, and we did have a chance to discuss this matter. We understand the argument of the Assistant Prosecutor, Mr. Harajli. Obviously, we can, in good conscience, Your Honor, argue for a personal bond in this matter, given that Mr. Johnson was on bond, I believe, for another file at the time, and I believe the statute indicates that he is not allowed to have another PR bond based on that fact. But what we would ask for, Your Honor, is a affordable cash bond and a tether if the court finds that to be appropriate. Mr. Johnson does live in Willis. I believe the alleged victim lives here in Ypsilanti. If you wanted to make Ypsilanti the hot zone, I don't think there'd be any reason why Mr. Johnson would need to be in Ypsilanti. He would have no problem with the no contact and the no go to in this situation. He is working for the Ford Motor Company, but he is currently on disability. He was not arrested doing anything illegal at the time. He was arrested at his sister's house. The police came over there looking for him, and he went into custody without issue. Obviously, these are serious allegations, but Mr. Johnson does not have any prior felonies, he indicates, and he is looking forward to resolving this matter. I'd ask the court to consider an affordable cash bond with that tether provision if the court sees fit. He will stay away from the alleged victim in this matter, and if the court wants to make Ypsilanti the hot zone again, I don't believe he has any need to be in the Ypsilanti, Judge.
Thank you. Any response from the people?
Nothing additional, Your Honor. Thank you.
All right. Mr. Johnson, your next court date will be a probable cause conference on August the 12th at 9 a.m. via Zoom. Should the matter not be resolved at that hearing, it will proceed to a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that there is probable cause crime was committed, probable cause you to commit the crime. Should the judge presiding over that hearing determine that probable cause does exist, the matter will be bound over, in other words, transferred to circuit court for trial. Do you understand that?
Yes.
Condition of bond, the defendant is not to use or possess alcohol, illegal drugs, or marijuana, not to leave the state of Michigan without permission of the court. The defendant is not to possess or purchase a firearm, ammunition, or other dangerous weapon. The defendant is not to have contact with LaShawna Hall, meaning absolutely no contact, no indirect contact with family or friends, no text message, email, social network posts, and telephone contact, two-way video contact, or any contact of any sort whatsoever. Defendant is barred from the address of 8813 Lagoon Drive, Ypsilanti, Michigan. And defendant is to not violate any criminal laws, to appear at all court hearings and other places as directed by the court. Court will take notice that virtually all of these conditions have been violated as a result of the arrest here. Therefore, in addition to the conditions placed on the record, the court is going to set bond in the amount of $50,000 to be posted either in cash or corporate surety to assure public safety. Should that bond be posted, the defendant is to acquire a tether prior to release, preventing the defendant from entering the 48197 and 4819 area zip codes. These conditions will be placed in law enforcement information network. Should you come into contact with the police, they would have access to that information. They would arrest based upon a violation of that bond. You understand all that, sir? Okay. Mr. Feaster, anything else on bond?
No, Judge. Could you just repeat the PCC date, please?
Certainly. We have the first date will be on the 12th at 9 a.m. and the preliminary exam on the 17th also at 9 a.m.
Thank you, Judge.
Thank you. All right, sir, you're all set. Stay safe, Mr. Johnson.
Your Honor, before the next defendant was brought out, I just wanted to inquire, is Mr. Wodzeski going to be seen today? Because he was my last matter.
He's set on here. Yeah. We
Okay, great.
List, so yeah, we haven't heard.
I'll stay on the call. I just wasn't certain.
Yeah. Good morning. Your name, please.
Good morning.
What's your name, sir?
Finney Brooks.
Brooks. Give me just one moment, okay?
Yeah.
Field State of Michigan versus Fernie and Brooks. Michigan State Police Incident M1212447521. Good morning.
Morning, Judge. Attorney Torshio Feaster, Assistant Public Defender on behalf of Mr. Brooks. Your Honor, we did have a chance to review the charges in this matter. We would waive reading and stand mute, Judge.
Thank you. Mr. Brooks, you understand the charge and the maximum penalty associated with this charge?
No.
I'm sorry?
No.
You do not? Come a little closer to the computer there.
I don't understand the charge. What the maximum penalty is.
This
Okay.
is the charge. I'm sorry, Mr. Judge.
Go ahead, Mr. Feaster.
Mr. Brooks, this is the charge we talked about when Judge Fink talked to you the other day. You had the other case you were arraigned on, the indecent exposure, and this is the RNC case, I believe, that we discussed. You recall that?
Yeah.
Okay.
Okay. So you understand the charge now that you've been reminded of it?
Yeah.
Okay. Would you like it read to you?
Yeah, Judge.
Okay, no problem at all. The allegation in this matter is that on July 29th of this year in Ypsilanti Township, Washtenaw County, state of Michigan, at E-course near Moss, you did buy, receive, possess, conceal, or aid in concealment of a automobile identified as a Chevrolet HHR, a stolen motor vehicle that you knew or had reason to know had been stolen, embezzled, or converted, which is a felony carrying a maximum penalty if convicted of a term of up to 5 years in prison, a $10,000 fine, or both. You understand that?
Yeah.
Sir, I need to advise you of certain rights. You do have the right to remain silent. Anything you say on the record can and would be used against you at trial. Do you understand that?
Yeah.
You also have the right to be represented by an attorney at all stages of these proceedings. That does include before, during, after trial, and at any time you're being questioned by a police officer. If you are unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yeah.
Court will stand mute to the charge, enter a not guilty plea on your behalf, and take a petition for the public defender to represent you in this matter. You have a good telephone number to reach you?
313-575-9072.
Okay. And public defender gathered an email address from you that ends in 1977 at Gmail. Is that the right email address for you?
RLB 0803-1977 @gmail.com.
Yep,
Yeah.
that's what we got. Okay. Reason we collect email and telephone information is the court may email or text you in the future with information about your case. Is it okay to do that with these contact points?
Yeah.
Okay. All right. And you're living in Redford right now?
Yeah.
All right. Okay. Based upon the information provided in the petition, the court will endorse the petition appointing the public defender to represent you in this matter. Do people have any issue or want to address bond? Excuse me.
I believe he indicated in the chat he does not plan to address the bond, Judge.
Oh, I'm sorry. I should read my messages. Okay, thank you.
We know you're busy, Judge.
Thank you,
All right.
Mr. Feaster. Thank you, Your Honor.
Thank you. All right, Mr. Feaster, you can proceed.
Yes, Judge, just briefly, Judge, as I stated earlier when I was speaking to Mr. Brooks, he was arraigned, I said in front of Judge Fink, it was Judge Cameron, I believe, on another charge for aggravated indecent exposure. That case did warrant a $1,000 10% bond. We also believe there's a possibility a probation violation is forthcoming. So we're not asking for a PR bond at this time, Your Honor. We're asking for a low cash bond so that Mr. Brooks can put together all of his files in this county and try to get everything wrapped up as conveniently as possible. So we'd ask the court to consider a low cash 10% bond, please.
Thank you. Okay. All right. Next court dates in this matter will be scheduled as follows. Excuse me. Next court date will be a probable cause conference on August the 12th at 9 a.m. Should the matter not be resolved at that hearing, it will proceed to a preliminary examination. The preliminary examination is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that there is probable cause crime was committed, probable cause you did commit that crime. Should the judge presiding on a hearing determine probable cause does exist, the matter would be bound over, in other words, transferred to circuit court for trial. Do you understand that?
Okay.
That hearing will take place on August 17th, also at 9 a.m. At the public defender's request, the court will set a 1,010% bond to assure appearance at future court dates. Given this is a non-assaultive crime, the court doesn't see any need for additional conditions. Other than, of course, you're not to violate any criminal laws and you need to appear for all of your court dates. Do you understand that?
Yeah.
Okay, all right. So you're all set for today. Stay safe, okay?
Thank you, Judge.
Can I say something?
We're not going to talk about the case, Mr. Brooks. I know your position on the case. We'll address that at the next court date and try to get these matters resolved.
You gotta address that. I got SSI. There ain't no way for me to pay my bond when my car is in jail with me. That's what I'm saying. So you gotta address real facts now. I didn't ask for it. I need a PI bond because how am I supposed to get out? But I got SSI. My car is in jail with me. But
Well,
nobody paid up.
We discussed this. You already have a cash bond on the other file, and you likely have a probation violation forthcoming. The judge did not want you to sit in jail with no potential credit, while we're waiting for those additional situations to be resolved. And so that's why we asked for a low cash bond.
So
You recall?
What if I don't get violated?
Well, then we can address your bond at the next court date and try to get you out.
Okay, so now I gotta sit in here to the 12th.
Yes, I think that's probably the best decision. Yes.
All right.
All right. Thank you, Judge.
All right, thank you. All right, you're all set, Mr. Brooks.
Right.
Good morning. Your name, please?
Nikki,
You slide a little closer to that computer so we can hear a little bit better. Thank you.
That's Miss McPhee, Judge.
Got it. All right. Field State of Michigan versus Magistrate McPhee. It's Washtenaw County Sheriff Incident 2151289. Good morning.
Morning, Jed Rajley on behalf of the people.
Thank you.
Morning, Judge. Attorney Feaster on behalf of Miss McPhee. Your Honor, we did have a chance to discuss the charges. We believed at the time of our meeting it was going to be a RNO judge, and I read her that statute. It actually has been charged as a DV, I believe, Judge.
That's
If you would not mind, please reading her that information, and she's stand mute, Judge.
Absolutely. No problem at all. The allegation, ma'am, is that on July 30 of this year in Ypsilanti Township, Washtenaw County, State of Michigan at 1103 South Harris Road, you did make an assault or assault and battery upon Michael Green. He's identified as a resident or former resident of your household and or an individual whom you have or had a dating relationship. This is a misdemeanor carrying a maximum penalty if convicted of up to 93 days in jail, a $500 fine plus court costs or both. Do you understand that allegation?
yes,
Were you able to read and sign the advice of rights form?
yes,
Do you have any questions with regard to your rights?
no,
The court will have you stand mute to the charge, enter a not guilty plea on your behalf, and review the information provided by the public defender with regard to appointment. Right page here. All right, information provided by the public defender indicates that you are residing in Monroe on East 2nd Street. Is that correct?
no,
That's where she was residing at the time of the arrest, Judge. She indicates she does not intend to go back there.
I was not living there.
Okay. All right.
I haven't lived in Monroe in over a year.
Okay.
Well, then please tell the judge where you were living.
1103 South Harris Street.
Okay. I'll come back to that in just a moment. What's the best telephone number to reach you?
I don't have a telephone.
No telephone? All right. And we provide with a Gmail address that ends in Mike15@gmail. Is that the best email address to reach you?
No, it's not.
Okay. What is your email address?
Love is lost 98.
Can you come a little closer to that computer? I'm just having a little hard time hearing.
Love is lost, 90 @gmail.
Thank you. The reason we collect email addresses is the court may contact you in the future with information about your case via email. Is it okay to use that email for that purpose?
Yes.
Okay. All right. You're working at a siding company right now?
Judge, I think you have the wrong CAA form from me, Judge. She's
Okay.
currently unemployed.
Okay. Her name's on this one. That's okay.
Okay.
You're unemployed, man. Okay. All right. Do you have any source of income or receive any state assistance?
Obviously, state assistance,
Okay. In what form?
Medicaid.
Okay. Thanks. Public defender is appointed to represent you. People have anything on bond in this matter?
Your Honor, I'll just note for the court that I did speak with Michael Green regarding the investigation this morning. His only concern is the do not go to and no contact order. If the court is able to address those conditions, I believe a PR bond would be appropriate.
Okay, thank you. Mr. Feaster, do you want to address bond?
Yeah, just briefly, Judge. Obviously, I'm not going to fight with Mr. Rajley on this one. What we would ask for, Judge, is we understand that Ms. McPhee cannot be around the individual named in the complaint, Judge. From our brief conversation, Judge, she does have two potential holds, one out of Monroe for disorderly, one out of Westland for a DWLS. She was made aware of that by me this morning. She indicated that she still wanted me to seek a PR bond on her behalf. She does have one minor child, and she is looking to fight, address, resolve this case. I'd ask the court to consider a PR bond, Judge.
Okay. All right. Given the nature of the allegations, the court will set bond conditions for public safety. These conditions are the defendant is not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card?
No,
Okay. Not to leave the state of Michigan without permission of the court. Not to possess or purchase a firearm, ammunition, or other dangerous weapon. Do you own any firearms?
no,
Not to commit any assaultive, terrorizing, frightening, intimidating, threatening, harassing, molesting, or stalking behavior towards any individual. Not to have contact with Michael Green. This means absolutely no contact, no indirect contact through family or friends, no text, message, email, social network posting, telephone contact, or any contact of any sort whatsoever. You understand that?
no.
Okay. What can I clarify for you on that point?
I live there. My things are at his house, but how am I supposed to get my stuff?
Well, you can return there to collect your personal belongings on a civil standby, but you will need to find an alternate place to stay while this matter is pending. Do you have a place where you can stay?
No,
I'll address that in just a moment. Defendant is not to the address of 1103 South Harris. Defendant may return there on civil standby with the Sheriff's Department to collect personal belongings, meaning when you get out of jail, just let the Sheriff's Department know you have a civil standby order. They know exactly what that's about. They'll walk you through their process to get you over there, escort you to collect personal belongings. Within 24 hours of release, you'll need to contact the court with the addresses to where you'll be staying. Defendant is not to violate any criminal laws, personally appear at all court hearings and other places as directed by the court. These conditions will be placed in the law enforcement information network, meaning should you come into contact with the police, they will have access to that information. Should they witness that a bond violation, that would result in an arrest for a bond violation. You understand that?
yeah.
Mr. Feaster, anything else on bond?
No, Judge, thank you very much.
Okay. All right, we'll set the matter for a pretrial conference on August 30 at 9 a.m. Defendant is released on a personal recognizance bond, subject to the conditions placed here on the record. That hearing will take place via Zoom. Are you familiar with Zoom, ma'am?
Are we on Zoom now?
We're on Zoom now, correct? Yep. So what you would need to do Zoom for yourself is either a smart device, like a smartphone or a tablet with a camera on it, or a computer with a camera on it. If you're unable to do that, you can come to the court and utilize the device in the court's lobby as well to achieve that. But the easiest thing to do, if you can do it, is just do it from home on a smart device. The public defender will be in touch with your next before your next court date, and they can walk you through the process of Zoom a little bit as well. What you're going to need though is a Zoom ID number, which is why it's important we get a mailing address for you. The court's going to mail you a notice with that Zoom information. If you don't receive that or otherwise don't have it as that court date approaches, you can certainly call the court and the clerks can give you that over the telephone as well. Okay. What happens when you initiate a Zoom call is you're going to go into what's called a waiting room first. And much like if you were in court in person, there's going to be a number of people waiting to be heard, their cases to be heard as well. So you may find yourself in that waiting room for a period of time. We just ask that you be patient and stay near your phone. So when you do be brought into the court environment, you're there and ready to go. Okay. All right. Released on a person for cognizance about something conditions placed here on the record. And again, pre-trial will be August 30, 9 a.m. via Zoom at 14B District Court. All right, ma'am, you're all set. Stay safe. Okay.
Does that mean I'm staying in this jail until? August
No.
30th?
You can leave today.
Oh,
You can leave today. You just need to make sure you're following the conditions of release. Make sure you're not utilizing any intoxicating substances, not having contact with a protected individual. And like I said, it's important that you get us an address as to where you're going to be once you establish that. Okay. Okay. All right. You're all set.
Thank you, Judge.
thank you.
Thank you.
Your Honor, while we're waiting, I see only Mr. Wadesky on my list from today, but one of my colleagues informed me you all were having some trouble arraigning a few folks yesterday. Will those be addressed today as well?
I personally had no trouble arraigning anybody yesterday.
Or
So
I guess
I have no idea.
okay, some folks had trouble listening to Magistrate Fink. Then sounds like
Okay. Apparently they got themselves pushed over to Monday because
okay.
I'm out of files.
Thank you.
Yep. That's really weird.
Hi,
Yes,
who did you have left?
we have Mr. Wendeski.
Okay, is that it?
That's it.
Okay, I'll get him right now.
Thank you.
You're welcome.
Mr. Meyer, while we're waiting, are you waiving reading on this matter?
No, Your Honor, we didn't see the charges loaded. Is this a township case?
No, that's a state case.
Okay, let me check again. Maybe I had them under the wrong name. It's WEDESKY.
Correct.
All right. Yeah, I'm still not seeing them on base, so we would ask the court read the charges.
Sure, no problem.
Thank you. I saw Mr. Wadesky this morning. I don't know what's going on.
Morning, sir.
Hello,
Your name, please?
my name is Timothy Wadesky.
Thank you. People of the State of Michigan versus Timothy Wadesky. This is case number 21F55091. The allegation is on July 30, 2021, the city of Ann Arbor County, Washington, State of Michigan at 368 Columbus Drive. You did make an assault upon Caitlin Holdren with the intent to do great bodily harm, less than the crime of murder. A felony carrying a maximum penalty if convicted of a term of up to 10 years in prison, a $5,000 fine, or both. Do you understand that?
Yes, sir.
Count two, you did make an assault or assault and battery upon Caitlin Holdren, individual whom you had a dating relationship. It's being charged as a third offense based upon convictions July 9, 2018 and March 13, 2013. That makes this a felony carrying a maximum penalty if convicted of a term of up to 5 years in prison, a $5,000 fine, or both. Do you understand that?
Yes, sir.
As these are felony charges, I need to advise you of certain rights. You do have the right to remain silent. Anything you say on the record can and would be used against you at trial. Do you understand that?
Yes, sir.
You also have the right to be represented by an attorney at all stages of these proceedings, including before, during, after trial, and at any time you're being questioned by a police officer. If you are unable to afford an attorney, one will be appointed to represent you at public expense. Do you understand that?
Yes, sir.
Where we stand mute to the charges, enter not guilty pleas as to both counts. Reviewing information provided by the public defender indicates the telephone number is 9595. Is that the best number to reach you?
Yep.
And you have an email address that is essentially your first last name at gmail.com?
Yes, sir.
Okay. And you're currently employed at Cottage Inn Pizza?
Yes, sir.
Okay. Based upon the information provided, the court will endorse petition appointing the public defender to represent you. The contact information, both telephone and email, are collected so the court can contact you in the future with regard to information about your case, possibly either by email or text. Is it okay to use those contact points for that purpose?
Yes, sir.
Thank you. All right. People addressing bond this morning?
Yes, Your Honor. Jen Rajli on behalf of the people. Most of what I'd like to say was reflected in the bond conform that was completed by my colleague. So I won't belabor any of that too much. There is just a history here that is quite concerning. Prior convictions for domestic violence are are not within this jurisdiction, so I'm lacking information about the victim. But with Ms. Holdren, there was a recently dismissed domestic violence third out of the 15th district in Ann Arbor. That was dismissed in January of this year when the victim failed to appear and testify. In this particular case, Ms. Holdren ran out of the residence trying to get away, screaming, "Save me" and "help me" and things like this to neighbors who eventually called police. She did inform police who investigated that she did think Mr. Wadesky was going to kill her while the assault was occurring. So with all of this in mind, I think the request for home confinement is substantiated by the factual circumstances here, or at least supported. In the alternative, I'd request a GPS tether with the hot zone on the address on Columbus Drive.
Thank you. Mr. Meyer? You're muted, Mr. Meyer.
Good morning, Your Honor. Sorry about that. Andrew Meyer on behalf of Timothy Wadesky. I did have an opportunity to meet with Mr. Wadesky yesterday and then again this morning to gather some information. I didn't have the charging documents in front of me at that time. I would note that Mr. Wadesky indicated that the address I provided the court was with his long-term girlfriend, Ms. Holdren, who is the alleged victim in this matter. He indicated to me he does have another residence. He could either reside with his brother in Westfield or I think another individual somewhere else. As indicated in the information I provided to the court, he is working at Cottage Inn Pizza. He works there as a manager and has had that job for several years now. He has completed some college. He also indicated to me that he does suffer from some mental health concerns, specifically depression. And he was involved in a car accident in 2011. He has received some treatment for that, and he would be willing to pursue further treatment while this matter is pending. He obviously understands he can't have any contact with the alleged victim in this matter while the matter is pending, and that he may not be able to return to the residence if the alleged victim is still residing there. However, Mr. Wadesky does not have many resources, so we'd ask the court consider a personal recognizance bond with conditions, and if the court has further concerns regarding public safety or violations of the no contact order, we'd ask that a tether be put in place.
Thank you. Mr. Wadesky, Mr. Meyer indicated you had alternate addresses to stay at. Can you provide the court with the most likely addresses to where you'd be and or where you'd like your mail to go while this matter is pending?
I don't know the exact address of the places, but it'd either be my brother or my parents.
Okay, I'll indicate that address to be provided upon release.
Yeah, I can get that.
All right. Let's get the next court dates on the record here first. Next court date in this matter will be a probable cause conference that will be scheduled for August the 12th at 9 a.m. 14A District Court via Zoom. If the matter is not resolved at that hearing, it proceed to what is called a preliminary examination. That is a hearing at which point in time the prosecutor must present sufficient evidence and or testimony that probable cause crime was committed and probable cause you to commit the crime. Should the judge presiding over the hearing determine that probable cause does exist, the matter will be bound over and over, it's transferred to circuit court for trial. Do you understand that?
Yep.
That will take place on August the 17th at 9 a.m. So two court dates are the 12th and the 17th respectively of August, both at 9 a.m. Both will take place via Zoom.
Okay.
All right. Court will set bond conditions to assure public safety. These conditions are the defendant is not to use or possess alcohol, illegal drugs, or marijuana. Do you have a medical marijuana card?
No, sir.
Defendant is not to leave the state of Michigan without permission of the court. Not to possess or purchase a firearm, ammunition, or other dangerous weapon. Do you own any firearms?
No, sir.
Not to commit any assaultive, terrorizing, frightening, intimidating, threatening, harassing, molesting, or stalking behavior towards any individual. Not to have contact with Caitlin Holdren. This means absolutely no contact, no indirect contact through family or friends, no text message, email, social network posting, telephone contact, two-way video contact, or any contact of any sort whatsoever, whether in jail or not in jail. Do you understand that?
Yes, sir.
Not to the address is 368 Columbus Drive in Ann Arbor, Michigan. Should you be released from jail, you can require a GPS tether prior to release with a 1 mile radius of not to go to that address. The one exception is you may return there to collect personal belongings on civil standby with a police officer. Do you understand that?
Yes, sir.
Okay. Mr. Meyer, did you have any questions or concerns on conditions?
No, the only thing I was thinking is, Mr. Wadesky, is the Cottage Inn Pizza restaurant within a mile of that Columbus Drive address that you provided the court?
No, but she's my employee there, and she's also living at my house. Like, it's my house.
Okay.
I don't know.
We
Well, these
discussed
are-
that. If she's living there, you may not be able to go back. I'm sorry, Your Honor.
Okay.
Am I allowed to get any of my things there, like when she's not there with like a police presence?
I addressed that when I went over the note not to go to. You can return that on what's called a civil standby, but you have to have a police officer with you. So when if you're released from jail, you can contact the police department, tell them you have a civil standby order. They'll walk you through that process. If she works where you work, you can't be there. Okay, plain and simple.
Your Honor, we would ask, in light of the fact that that is his employer, that there be permission for incidental contact at work. I don't know if they work the same shift or what.
Yeah, it's an absolute bar on contact. This is going on too long. She there's a power relationship there as well. He's got to figure something out. Okay. Do people have anything else on bond?
Nothing further, Your Honor. I think I just missed was there a cash or surety bond amount that you said?
Haven't got to that point. I just want to make sure that everybody understands the conditions and there's no other issues with regard to those conditions.
Understood.
Given the totality of the circumstances, and given that there's a pattern of ongoing behavior here, and given that the court does find that the alleged victim in this matter would be in continued risk of harm, regardless of any conditions placed on the record, the court will impose a cash bond as well to ensure that public safety, because the court is not satisfied that these conditions would be sufficient on their own. So the court will impose a cash bond in the amount of $25,000, be posted in cash or corporate surety, subject to the conditions placed here on the record. Okay, you're all set, sir. Stay safe.
Thank you.
And Mr. Wadesky, good luck to you. An attorney from my office will meet with you before your next court date.
Thank you.
Thank you, Your Honor. Have a good rest of your weekend.
That's all we had. Yep. We'll